We've got April Smith coming. Oh, there it is. Just popped up. As soon as I said it, of course. Good morning. Are you April Smith?
Yes.
And Mr. Lewis, will your client waive the formal reading of the motion?
She does, Judge.
So it's just open.
It is, Judge, and just to update the court, it's my understanding that Ms. Smith is going to plead not true to counts 1 and 2. Frankly, I don't blame her. I have reached out multiple times today, or the detectives asked them to bring those new cases. I believe I even did so in May, if I'm correct, and I still don't have them. So I don't intend to proceed on them. We're just going to go open to the court on the full range of punishment, with the understanding that if for some reason those cases are brought in, I don't intend to proceed on this.
Okay. All right, ma'am, or Mr. Lewis, will she waive the formal reading of the motion?
She does, Judge.
Ms. Smith, in clause number 19, 33472, I have a motion to revoke your community supervision. This shows that you were placed on probation August 3rd of 2020 for the offense of theft of property with previous convictions. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes.
And then it alleges that you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions May 1st of 2025 in Jefferson County. And is that true or not true? Count 2 alleges that you committed the new offense of possession of a controlled substance, penalty group 1, May 1st of 2025 in Jefferson County. And is that true or not true? Count 3 alleges that you failed to immediately report to the probation officer your arrest on May 1st of 2025. And is that true or not true?
True.
Count 4 alleges that you possessed a drug, methamphetamine, on May 1st, 2025 in violation of your order. Is that true or not true? Count 5 alleges that you were at a location other than your residence at approximately 1:29 a.m. on May 1st of 2025. And is that true or not true? And then count 6 alleges that you're behind in your court-assessed fees as of May 19th, 2025 in the amount of $1,713.16. Is that true or not true? Did you enter your pleas of true to counts 3, 5, and 6 freely and voluntarily? And because those counts are actually true. I have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Y'all have marked off that this is a plea bargain, but it's really not. So I'm going to make that change because...
The only reason I did that is because we had the agreement.
Oh,
the new
No,
cases.
so it's fine.
okay, so there is an agreement, actually.
There was actually.
Thank you, Mr. Lewis.
Yes, and Judge, I'm sorry, I misspoke earlier. The offense dates are in May. We checked after our last setting in January.
Right.
I asked them to file them, and they still haven't.
Okay.
Yesterday.
Okay, thank you. So the agreement is that the state is willing to not go forward, or if they do at this time receive those cases, not pursue them. And that's part of that plea agreement, which means no matter what I do within the range of punishment, which is up to 2 years in the state jail prison, you're waiving any right to appeal. You understand? State tenders number 1.
No objection, Judge.
It's admitted. Any evidence that Ms. Smith is not competent?
No, Judge.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 5, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I'm going to reset your case for sentencing so the probation department can do an updated report. It'll just give me more information about you, your case, what's been going on, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. Okay? See you back at sentencing.
Let's break down what just happened with April Smith. The prosecutor brought up 6 different probation violations against her. But here's the twist. The police hadn't actually filed the paperwork for the 2 biggest charges yet. So the lawyers made a smart deal. The state agreed to completely drop those 2 heavy charges as long as April admitted to the smaller mistakes, like missing a curfew and owing court fees. By doing this, April avoids facing severe prison time for the new cases. The judge accepted this deal, but instead of giving her a punishment right away, she paused the case. She wants an updated report on April's behavior first. This gives April and her lawyer extra extra time to bring good proof to court to ask for a lighter sentence.
Thanks.
Good morning, sir. Are you Kelvin Johnson?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will.
Judge, with the court's permission, we need to go on second degree count, so whichever the court prefers.
Somebody didn't sign.
The defendant, I signed in the wrong spot. Sorry.
I didn't get him.
That's okay. Thank you. Mr. Johnson, in cause number 25, DCCR 1781, you're charged with the state jail felony offense of theft of property with previous convictions from October 9th of 2025. The indictment alleges you were previously convicted of theft August 18th of 2022 and January 5th of 2023 and then April 15th of 2024. The indictment further alleges that you were convicted of delivery of a controlled substance, a state jail felony, February 9th of 2004, 2 cases on that same date of delivery of a controlled substance. And how do you plead to that charge? And are those prior convictions all true?
Yes, ma'am.
Did you enter your plea of guilty and true, freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yeah.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 5 years in prison, which means you're leaving your punishment up to me. And as long as I follow the agreement, I cannot give you more than 5 years. Give you 5 years, I can give you less, I can consider probation. All of that will be determined when we come back for sentencing and I get more information and a pre-sentence report and things like that. You have an absolute right to have a jury come in and decide 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them. If we go forward this way, then you're waiving that. And is that what you want to do?
No.
Right. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Johnson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely, and voluntarily. I find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do that report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas, and he'll present it to me on your behalf when we come.
Yes, ma'am.
All right, we'll see you back at sentencing. You go back with the bailiff. Good morning, sir. Are you Donald Cogdill? Are you Donald Cogdill?
Yes, ma'am.
And Mr. Cogdill, can you hear me okay?
Barely.
In cause number 26, DCCR, 0005, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from June 25th of 2025. Your indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. Then the indictment goes further to allege that you were previously convicted of burglary of a habitation December 22nd of 1993. After that was final, you were convicted of burglary of a habitation November 7th of 1994. And then after that, you were convicted of possession of cocaine with intent to deliver, a first-degree felony, January 30th of 2009. And then after that was final, you were convicted of indecency with a child by exposure, a third-degree felony, September 21st of 2017. What all of that means is that if you go to trial and you're found guilty in this current case, and if at least 2 of those prior offenses are true, that you were convicted, your punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand? Do you understand that?
The way he's talking is going to be a lot better, worse. I mean, I don't understand.
What do you not understand?
You understand the range of punishment is 2 to 20 years, correct?
I ain't gonna make it that long anyways.
Look, I just need to know if you understand that if you go to trial and you're found guilty, what the consequences could be. And the consequences could be a minimum punishment of 2 years up to 20 years. Do you understand that?
Yes, I understand that part.
Okay. So the state has made an offer. I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker that shows that the offer they've made, if you wanted to enter a plea of guilty, is for an 8-year term in prison. You have every right to reject that and have a jury determine if you're guilty or not and what your punishment is. I just want to make sure you understand what your options are if you want to plead guilty and what your consequences could be if you go to trial. Do you understand all of that?
Well, I better take the,
Just listen to my questions. Do you understand that? What your options are and what your consequences could be. I just need to know if you understand it. It doesn't matter. Listen, I'm not asking you if you like what their offer is.
I know.
Okay? I don't care if you like it or not. It doesn't matter. I just need to know if you understand what it is. Do you understand?
Yes.
And so, go
I'm
ahead.
sorry, Judge, if I may, the state, based on the facts of the offense itself, the state would be more than willing to cap that at 8 years. He received 15 last time on that evading, so we were actually even going to come to the court with seeking your permission for that 8 based on the facts of the offense. But with everything that he has in his past, the state would certainly be willing, based on the underlying facts, to cap it if they make any difference.
Have y'all talked about that?
No, we haven't talked about a cap.
Why don't y'all go back and talk
Okay.
about it and I'll hold it for a minute.
Donald Cogdale's case shows just how much your past record can come back to haunt you in court. On paper, his current charge, evading arrest, is usually a minor felony. But because Donald has several serious past convictions on his record, the law allows the state to boost his maximum punishment up to 20 years in prison. Donald was clearly confused and overwhelmed by how high that number was. He had already rejected the prosecutor's offer for an 8-year sentence. But seeing how nervous Donald was, the prosecutor stepped in at the last second with a better deal, an 8-year cap. That means if Donald agrees, the absolute maximum time the judge can give him is 8 years. But the judge could easily give him way less. It takes a massive 20-year risk completely off the table.